Hi, this is Attorney Kip from Malek and Malek. Today, I'm going to be talking about a recent magistrate decision. So this would be an appeal to the 10th District and that's where these mandamus, they're called mandamus. I think I've talked about this in another video. Be that as it may, it's a mandamus action, and it's state versus XREL, Autozone versus the Industrial Commission. So it's a mandamus, and it's just rendered very recently, August 10th, 2022. And this is important. The reason why I'm bringing this up, why it's come to my attention, is this is dealing with this 412356F thing. And if you remember, I've talked about 412356F in prior videos. And 412356F was this new case law, or this new, not case law, but it was a new addition to the Ohio Revised Code, and essentially got rid of what this thing called voluntary abandonment, and that it was put in there to fix something that was a bad decision for claimants, we think, in this Klein versus Precision Excavating case. Bottom line is, it's not been interpreted in a manner that a lot of folks are super happy about. And in short, the revised code 412356F, and this was amendment in HB 81 on September 15th, 2020. It says this, and these are the sentences that are relevant. The first sentence: if an employee is unable to work or suffers a wage loss as a direct result of an impairment arising from an injury or occupational disease, the employee is entitled to receive compensation under this section, provided the employee is otherwise qualified. So that's fine. That's cool. But this next sentence sucks. And the next sentence is, if an employee is not working or suffered a wage loss as a direct result of reasons unrelated to the allowed injury or occupational disease, the employee is not eligible to receive compensation under this section. And this has been used. The second sentence has been used with great effect to limit when people get comp. It's not great. Essentially, a lot of times, if you got terminated, if you got an injury and you got terminated, in the past, the rule was, it was this case called Pretty Products, and the rule was that if you were got injured, you were involuntarily unable to work, so you're involuntarily left the workforce. But if you did something to, like, you flipped off your manager or you punched your coworker or something, you did something, and that would be called a voluntary. You voluntarily, by your voluntary action, you left the workforce. So in the first instance, involuntary, you voluntarily abandoned the workforce, you got injured, you can't work because of your work injury. In the second instance, you punched somebody, you flipped off your manager, you did something by your action, you voluntarily abandoned the workforce. Okay, that was the rule before. And then the rule before is if you got injured and you were essentially involuntarily removed from the workforce, so then you can't then voluntarily leave the workforce. But this Klein case, and I've done that in other videos, I'm not going to go over there, that kind of threw everything in the works. And then this amendment was added to allegedly fix it. It didn't really. It added more problems than it solved. But be as it may, this case is one of those situations, and the facts of this case is, and why this is relevant is, and this is why this might be relevant to your situation. So this guy got an injury on June 15th, 2020. The claim was allowed, and then it looks like he might have gone back to work with restrictions or something. And then on September 5th, 2020, he was involved with an argument with an employer, and his employment was terminated. So then what ended up happening is on November 16th, 2020, he underwent an approved right shoulder surgery for this claim. So what I mean approved is, it was requested through the claim. It was authorized by the managed care organization. The workers' comp said, hey, this is related to your work injury, we're paying for this. So the surgery was approved, and it was paid for through the claim. And so the issue in this case is he was requesting comp from the day of the surgery and afterwards. So from November 16th, 2020 and onwards. So this is how the 10th District has interpreted this case. I'm going to make another video where the Industrial Commission has similar facts, and they interpret it the other way. So if you look at, as far as who has more authority, well, the 10th District has more authority, or they have authority, or they're the ones who set authority for the Industrial Commission. But it's interesting how how it's interpreted. So what happened is this guy applied, and then it looks like the SHO granted it, and then I think the employer filed a mandamus. So the employer wasn't happy about this, I think, and then so yeah, they filed a writ of mandamus, and then so it's to the 10th district. And so what ended up happening is the magistrate basically determined this. And there's it's interesting because they're talking about there's basically nothing ambiguous in the statute the way it's written, and only when a definitive, and they're citing this case, only when a definitive meaning proves elusive should rules for construing ambiguous language be employed. Otherwise, allegations of ambiguity becoming self-fulfilling. And they're citing this State versus Porterfield, which is a House Supreme Court case. So basically, they're saying, hey, if it's not ambiguous, you're not gonna apply rules that apply to ambiguous statutes because there's nothing ambiguous about it. It's pretty clear. It's pretty crystal clear. And then, moreover, administrative deference has no place in the face of an unambiguous statute. So that's basically saying. And here's the thing: the Industrial Commission, the BWC, that's administrative, and so they're saying, the Industrial Commission, this is a statute, it's crystal clear, there's no ambiguity, you got to apply it as it's written, okay? And when you do, that's a problem. So he's saying there's two sections, and I read the sections before, but essentially 412356F, the first section, pursuant to the first section, employees entitled to receive compensation if the employee is unable to work or suffers the wage loss as a direct result of impairment arising from an injury or occupational disease. First thing. And the second thing, as the first section, and so he's saying the first section applies here, the claimant was entitled to receive compensation because he underwent an authorized surgery to treat the allowed conditions on November 16th, 2020. The claimant was unable to work as of the date of this injury. So there's no ambiguity, there's no question there. He underwent the surgery for conditions allowed in the claim. And he goes on further. At that point, his failure to work was not a direct result of reasons unrelated to the allowed work injuries. And he goes on further. His reasons for not working up until the date of the surgery were irrelevant for the purposes of determining his eligibility for, he says, wage loss compensation after the surgery due to the allowed conditions. Okay? So, and he says that even if it were assumed that the claimant was not working prior to November 16, 2020 due to his termination from his former position of employment, once the claimant underwent surgery due to his allowed workplace injury, the reasons he was not working could no longer be directly attributable to reasons unrelated to the workplace injury, i.e. his termination. So this is an important decision for you because it's basically saying, hey, I don't care if this guy got terminated. I don't care if he flipped off his manager or if he punched his coworker. But bottom line is, this surgery was paid through the claim. It was approved in the claim. It was directed at the conditions allowed in the claim. And the reason he can't work now is because he had the surgery in the claim. That's the deal in this instance. And so that's the reason why he's entitled to comp. What's interesting is court did not require claimant to renew entitlement to receive comp, i.e. the court didn't. In some of these other cases, and I'm going to talk about other cases in other videos, but they kind of make the injured worker had to show that they kept on applying to work and kept on working, or they tried to work, and then they had surgery. And at that point, it was okay because he did this extraordinary effort to show that he was trying to work or he was working. In this case, the court is like, that's not necessary. That person didn't have to show an attempt to return to work or they didn't have to have actually returned to work before the surgery in order to be entitled to comp, even though they may have been terminated by their employer. So that's a good decision. That's good for you, the injured workers. One thing I'm going to point out, though, and I'm going to talk about this in another video, but if you look, there's soft things that go on behind these decisions that aren't written into the cases. There's soft reasons. And I think one of the soft reasons, if you look, so he's terminated on September 16th, 2020. So he was working up until that time, or September 5th anyways, and then he's terminated September 16th, 2020. He had the surgery on November 16th, 2020. So it's not that much time difference. So between the time he was terminated and the time he had the surgery. There's going to be another case I'm going to talk about where there is a pretty significant difference. very similar facts, and they said this person is not entitled to compensation. So that's the case. It's a new appellate decision, and it's a good case. It's good for you. I don't know if the employer is going to appeal it. The employer can appeal these things to the Supreme Court. If it goes to the Supreme Court could say, screw the magistrate's decision, that we actually agree with the employer, and so this person's not entitled to comp. And more importantly, folks with similar fact patterns aren't entitled to comp, and if they have similar fact patterns. So we'll see. We'll have to keep an eye on it. This was just rendered, again, August 10th, 2022, and we'll see how things go. So you've been listening to this video. As I explain at the end of all these videos, I highly recommend that if you have any questions or any concerns, or if your workers' comp claim is at all kind of complicated, whatever, you need to reach out to a workers' comp attorney. You could reach out to us, or there's many competent workers' comp attorneys in Ohio. Just search on Google, you'll find them, talk to them, present them with your situation. They might need to get involved. They might be able to give you advice, but don't do the stuff on your own. It's too complicated. You're going to create too many problems for yourself. It's going to be worth the time and energy and the effort to get somebody involved. So with that being said, you've been listening to Kip Malek at Malek Law Firm. If you have questions, concerns, email, call our office, leave comments in the comments section, and I appreciate you listening to this.